Question 1. Cost-benefit analysis shows that obtaining a Montana concealed weapon permit involves understanding specific legal responsibilities. Considering Montana Code Annotated, MCA, Title 45, Chapter 8, Part 3, which of the following approaches best reflects the legal and ethical obligations of a permit holder when carrying a concealed firearm in Montana? Option A. Assuming the permit allows carrying a concealed firearm in any location within Montana, as long as it remains concealed. Option B. Interpreting the permit as a justification to use the concealed firearm in any situation where the permit holder feels uncomfortable or threatened. Option C. Believing that the permit negates the need to inform law enforcement about the concealed firearm during a lawful traffic stop. Option D. Strictly adhering to all statutory prohibitions on carrying in designated locations, and understanding the duty to inform law enforcement of the firearm's presence during a lawful stop. Correct answer is D. Strictly adhering to all statutory prohibitions on carrying in designated locations, and understanding the duty to inform law enforcement of the firearm's presence during a lawful stop. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an individual to balance their right to self-defense with the legal obligations and responsibilities associated with carrying a concealed weapon in Montana. Misinterpreting or disregarding Montana's specific concealed weapon permit laws can lead to serious legal consequences, including criminal charges and the revocation of permit privileges. The core challenge lies in understanding the nuances of when and where a concealed weapon can be legally carried, and what constitutes lawful use. Correct approach analysis. The best professional practice involves a thorough understanding and strict adherence to Montana Code Annotated, MCA, Title 45, Chapter 8, Part 3, which governs concealed weapons. This approach emphasizes knowing the specific locations where carrying a concealed weapon is prohibited by law, such as federal buildings, courthouses, or schools, unless specific exceptions apply. It also necessitates understanding the legal definition of concealed and the requirement to inform law enforcement of the presence of a firearm when lawfully stopped. This approach is correct because it directly aligns with the statutory requirements for obtaining and maintaining a concealed weapon permit in Montana, ensuring responsible and legal firearm possession. Incorrect approaches analysis. One incorrect approach involves assuming that a concealed weapon permit grants unrestricted carrying privileges anywhere within Montana. This fails to recognize that MCA 45-8-361 explicitly lists prohibited places where carrying a concealed weapon is illegal, regardless of permit status. This approach is ethically and legally flawed as it disregards specific statutory limitations designed to protect public safety in sensitive locations. Another incorrect approach is to believe that the permit absolves the permit holder of the duty to inform a law enforcement officer of the presence of a concealed firearm during a lawful stop. Montana law, as outlined in MCA 45-8-36111, requires a permit holder to disclose the presence of the concealed weapon to the officer. Failing to do so constitutes a violation of the law and can lead to penalties. A third incorrect approach is to interpret the right to carry a concealed weapon as a license to use it in any situation where the permit holder feels threatened, without considering the legal standards for self-defense in Montana. Montana law, under MCA 45-3-102, requires that the use of force, including deadly force, must be reasonably necessary to prevent imminent death or serious bodily harm. This approach is incorrect because it conflates the right to carry with the justification for using the weapon, ignoring the critical legal thresholds for self-defense. Professional reasoning. Professionals in Montana seeking or holding a concealed weapon permit should adopt a proactive and informed approach. This involves not only passing the required training, but also regularly reviewing and understanding the most current Montana statutes related to concealed carry and self-defense. When interacting with law enforcement, always err on the side of caution and compliance with disclosure requirements. In any situation where the use of a firearm is contemplated, a thorough understanding of the legal justification for self-defense, based on imminent threat and necessity, is paramount. This decision-making process prioritizes legal compliance, public safety, and responsible firearm ownership. Question 2. Implementation of Montana's concealed weapon permit, CWP system requires permit holders to understand specific location-based restrictions. A CWP holder in Montana is traveling and encounters a building with a sign stating "No firearms allowed." Considering Montana law, what is the most appropriate course of action for the CWP holder? Option A. The CWP holder may carry a concealed weapon into the building if they believe the sign is not legally enforceable or if they do not perceive an immediate threat. Option B. The CWP holder must not carry a concealed weapon into the building, as this signage indicates a prohibition that must be respected, regardless of the permit. Option C. The CWP holder may carry a concealed weapon into the building because their CWP signifies they have met the state's requirements and are trusted to carry. Option D. The CWP holder may carry a concealed weapon into the building, as Montana law only prohibits carrying in specific, statutorily defined locations, and a simple sign is not sufficient to create a new prohibition. The correct answer is B. The CWP holder must not carry a concealed weapon into the building, as this signage indicates a prohibition that must be respected, regardless of the permit. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent tension between an individual's right to self-defense and the state's interest in public safety and regulated firearm ownership. A concealed weapon permit, CWP holder in Montana, must navigate the complexities of where their permit allows them to carry, understanding that certain locations are off-limits regardless of permit status. Misinterpreting these restrictions can lead to serious legal consequences, including permit revocation and criminal charges, undermining public trust in responsible permit holders. Careful judgment is required to ensure compliance with Montana law. Correct approach analysis. The best professional practice involves a thorough understanding and strict adherence to Montana's specific statutory prohibitions regarding carrying concealed weapons, even with a valid CWP. This approach requires the permit holder to proactively consult and internalize the provisions of Montana Code Annotated, MCA Title 45, Chapter 8, Part 3, which outlines the places where carrying a concealed weapon is prohibited. This includes, but is not limited to, federal buildings, courthouses, and correctional facilities, as well as any place where the carrying of firearms is prohibited by federal law. The permit holder must assume responsibility for knowing these restrictions and exercising due diligence to avoid prohibited areas. This aligns with the ethical obligation of a CWP holder to be a responsible and law-abiding citizen, thereby upholding the integrity of the permit system and public safety. Incorrect approaches analysis. Relying solely on the presence of a CWP to grant unrestricted carrying privileges in all public spaces is a significant regulatory failure. Montana law explicitly carves out exceptions to where a CWP holder may carry. Assuming that a CWP supersedes all other signage or posted restrictions is a dangerous misinterpretation of the law and demonstrates a lack of due diligence. Another incorrect approach is to assume that if a location does not have explicit signage prohibiting firearms, it is permissible to carry a concealed weapon. Montana law does not require explicit signage for all prohibited locations. Many prohibitions are statutory. Failure to consult the MCA and understand these statutory prohibitions is a direct violation of the law. Finally, believing that personal discretion or a perceived lack of threat in a particular location negates the legal restrictions on carrying a concealed weapon is also a regulatory and ethical failure. The law is not based on subjective assessments of immediate danger, but on objective statutory prohibitions designed to maintain public order and safety in specific environments. Professional reasoning. Professionals seeking or holding a Montana concealed weapon permit should adopt a proactive and diligent approach to understanding their legal obligations. This involves 1. Consulting the most current version of the Montana Code Annotated, MCA, pertaining to concealed weapons. 2. Familiarizing themselves with all statutory prohibitions, not just those indicated by signage. 3. Seeking clarification from the Montana Department of Justice or a qualified legal professional if any ambiguity exists regarding prohibited locations. 4. Prioritizing compliance with the law above personal convenience or assumptions. 5. Regularly reviewing any updates or changes to Montana's firearm laws. Question 3. To address the challenge of understanding the precise limitations of a Montana concealed weapon permit, What is the most legally sound and professionally responsible course of action when considering carrying a concealed firearm into an establishment where alcohol is sold and consumed? Option A. Carry the concealed weapon but remain discreet and avoid consuming alcohol, believing that such behavior mitigates any legal risk. Option B. Refrain from carrying a concealed weapon into the establishment if it is a place where alcohol is sold and consumed, as Montana law generally prohibits this even with a permit, unless specific legal exceptions apply. Option C. Assume that a valid Montana concealed weapon permit allows for concealed carry in any establishment, including bars and taverns, as the permit signifies a level of trust and training. Option D. Rely on the advice of other concealed weapon permit holders who frequent such establishments to determine the legality of carrying a firearm. Correct answer is B. Refrain from carrying a concealed weapon into the establishment if it is a place where alcohol is sold and consumed, as Montana law generally prohibits this even with a permit, unless specific legal exceptions apply. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an individual to navigate the intersection of personal rights and public safety regulations concerning concealed carry in Montana. The core difficulty lies in understanding the nuances of Montana law regarding where a concealed weapon permit holder may legally carry a firearm, especially in establishments that serve alcohol. Misinterpreting these laws can lead to serious legal consequences, including permit revocation and criminal charges, as well as potential safety risks. Careful judgment is required to ensure compliance with all applicable statutes. Correct approach analysis. The best professional practice involves a thorough understanding and strict adherence to Montana's specific statutes governing the carrying of concealed weapons. This means recognizing that Montana law, under MCA 45-8-361, prohibits carrying a concealed weapon in a place where alcohol is sold and consumed, such as a bar or tavern, even with a valid permit, unless the establishment has a specific exception or the individual is an employee acting within the scope of their employment. Therefore, the correct approach is to refrain from carrying a concealed weapon into such an establishment if it is not explicitly permitted by law or if the individual is not an employee. This approach prioritizes legal compliance and public safety by respecting the legislative intent behind these restrictions. Incorrect approach is analysis. One incorrect approach is to assume that a valid Montana concealed weapon permit, CWP, grants unrestricted carry rights in all locations, including bars. This assumption is flawed because Montana law explicitly carves out exceptions to where a CWP holder can carry, particularly in establishments where alcohol is served. Relying solely on the existence of a permit without understanding its limitations is a direct violation of MCA 45-8-361. Another incorrect approach is to believe that simply being a patron and not an employee negates the prohibition. Montana law does not differentiate between employees and patrons in this specific prohibition. The restriction applies to anyone carrying a concealed weapon into a bar or tavern, regardless of their role, unless specific exceptions apply. A further incorrect approach is to rely on hearsay or informal advice from other permit holders or the general public regarding carry locations. Such information is not legally binding and may be inaccurate or outdated, leading to a misunderstanding of current Montana statutes. Legal compliance must be based on the official text of the law. Professional reasoning. Professionals in Montana seeking to carry a concealed weapon should adopt a decision-making framework that begins with a comprehensive review of the Montana Code annotated MCA, specifically Title 45, Chapter 8, Part 3, concerning firearms and weapons. When encountering a situation with potential restrictions, such as entering an establishment that serves alcohol, the professional should actively seek clarification by consulting the MCA directly or by contacting the relevant state agency responsible for issuing CWPs for definitive guidance. This proactive approach ensures that actions are grounded in legal fact rather than assumption or conjecture, thereby upholding both personal rights and public safety responsibilities. Question 4. The review process indicates an applicant for a Montana Concealed Weapon Permit (CWP) has a prior misdemeanor conviction for domestic violence. Considering Montana Code annotated Title 45, Chapter 8, Part 3, which of the following represents the most appropriate course of action for the permitting authority? Option A. Deny the permit application and advise the applicant that any history of domestic violence, even a misdemeanor, permanently disqualifies them from obtaining a CWP in Montana. Option B. Issue the permit without further investigation, assuming that all misdemeanor domestic violence convictions are disqualifying under Montana law. Option C. Conduct a detailed legal analysis of the specific domestic violence conviction to determine if it meets the statutory criteria for disqualification under Montana law, considering any applicable federal definitions and Montana-specific provisions. Option D. Automatically deny the permit application based on the presence of any domestic violence conviction, regardless of its specific classification or details. The correct answer is C. Conduct a detailed legal analysis of the specific domestic violence conviction to determine if it meets the statutory criteria for disqualification under Montana law, considering any applicable federal definitions and Montana-specific provisions. Explanation. The review process indicates a scenario where an applicant for a Montana Concealed Weapon Permit, CWP, has a past misdemeanor conviction for domestic violence. This situation is professionally challenging because it requires a nuanced understanding of Montana's specific firearm laws, particularly concerning prohibited persons, and the discretion afforded to the permitting authority. The challenge lies in balancing public safety concerns with an individual's right to self-defense, as interpreted by Montana statutes. Careful judgment is required to avoid both erroneous denial and the issuance of a permit to someone who may pose a risk. The best professional approach involves a thorough review of the applicant's criminal history against the specific disqualifying criteria outlined in Montana Code Annotated MCA, Title 45, Chapter 8, Part 3. This includes a detailed examination of the nature of the domestic violence conviction, the specific statute violated, and whether it falls under the definition of a misdemeanor crime of domestic violence, as defined by federal law and as incorporated or addressed by Montana law. The permitting authority must then apply the statutory criteria for disqualification, considering any applicable exceptions or expungement provisions under Montana law. This approach is correct because it adheres strictly to the legal framework established by Montana for CWP eligibility, ensuring that decisions are based on objective legal standards rather than subjective assumptions. It prioritizes public safety by correctly identifying and applying disqualifying offenses while respecting an applicant's rights under the law. An incorrect approach would be to automatically deny the permit solely based on the presence of any domestic violence conviction, without further investigation into the specifics of the conviction and its classification under Montana law. This fails to acknowledge that not all domestic violence convictions may result in disqualification under MCA 45-8-361, which references federal definitions and may have specific Montana nuances. Such an approach risks an unlawful denial. Another incorrect approach would be to grant the permit without a comprehensive review of the conviction's details, assuming that all misdemeanor domestic violence convictions are automatically disqualifying. This overlooks the possibility that the conviction might not meet the precise legal definition of a disqualifying offense, or that Montana law might provide for exceptions or relief in certain circumstances. This approach could compromise public safety. A third incorrect approach would be to rely on general assumptions about individuals with past domestic violence convictions, without consulting the specific Montana statutes and any relevant case law or administrative rules governing CWP issuance. This demonstrates a lack of due diligence and a failure to apply the law as written, potentially leading to arbitrary or capricious decision-making. Professionals should employ a decision-making framework that begins with a clear understanding of the governing statutes, MCA Title 45, Chapter 8, Part 3. This involves identifying the specific disqualifying criteria, researching the applicant's criminal history in detail, and cross-referencing this information with the statutory requirements. If the conviction appears to be disqualifying, the professional should then investigate any potential exceptions or relief provisions available under Montana law. Documentation of the entire review process, including the legal basis for the decision, is crucial for accountability and transparency. Question 5. Examination of the data shows that a Montana resident, legally possessing a valid concealed weapon permit, CWP, is stopped by a law enforcement officer for a minor traffic violation. The officer approaches the vehicle. What is the most appropriate and legally compliant course of action for the permit holder in this specific Montana context? Option A. Remain silent about the concealed weapon, hoping the officer does not notice it during the interaction. Option B. Only reveal the concealed weapon if the officer directly asks if the individual is carrying a firearm. Option C. Immediately and truthfully inform the officer of the presence of the concealed weapon and present the Montana concealed weapon permit when requested. Option D. Immediately reach for the concealed weapon to present it to the officer without being prompted. The correct answer is C. Immediately and truthfully inform the officer of the presence of the concealed weapon and present the Montana concealed weapon permit when requested. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an individual to navigate the intersection of personal rights, public safety, and specific state statutes regarding concealed carry. The challenge lies in understanding the nuances of Montana law concerning the lawful carrying of a concealed weapon, particularly when interacting with law enforcement, and avoiding actions that could lead to legal repercussions or compromise public trust. Careful judgment is required to ensure compliance with all applicable statutes and to act in a manner that is both legally sound and professionally responsible. Correct approach analysis. The best professional practice involves immediately and truthfully informing the law enforcement officer of the presence of a concealed weapon and presenting the Montana Concealed Weapon Permit, CWP, when requested or when interacting with an officer during a traffic stop or other lawful encounter. This approach is correct because Montana law, specifically Montana Code Annotated, MCA 45-3-324, requires a permit holder to, upon demand of a peace officer, exhibit the permit and surrender the concealed weapon. Transparency and immediate compliance with statutory requirements are paramount to avoiding legal issues and demonstrating responsible firearm ownership. This proactive disclosure fosters a safer interaction for both the permit holder and the officer. Incorrect approach is analysis. One incorrect approach is to remain silent about the concealed weapon and hope the officer does not notice it. This is professionally unacceptable because it directly violates MCA 45-3-324, which mandates disclosure upon demand. Failure to disclose can lead to charges of carrying a concealed weapon without a permit or obstruction of justice, even if the individual possesses a valid CWP. It also creates an unnecessarily dangerous situation for the law enforcement officer who is unaware of a potential threat. Another incorrect approach is to only reveal the concealed weapon if the officer specifically asks if the individual is carrying a firearm. While this might seem like a partial compliance, it still falls short of the statutory requirement. MCA 45-3-324 language, upon demand of a peace officer, implies a proactive duty to inform, not merely a reactive one. Waiting for a direct question can be interpreted as an attempt to conceal information and may still result in legal consequences. A third incorrect approach is to immediately reach for the weapon to present it without being prompted by the officer. This is professionally unacceptable as it can be perceived as a threatening gesture by the law enforcement officer, escalating the situation unnecessarily and potentially leading to a dangerous confrontation. The law requires presentation upon demand, not an unsolicited, immediate display that could be misinterpreted. Professional reasoning. Professionals in situations involving concealed carry should adopt a decision-making framework that prioritizes legal compliance, officer safety, and de-escalation. This framework involves 1. Understanding and internalizing the specific statutory requirements of Montana law regarding concealed carry and interactions with law enforcement. 2. Practicing clear, honest, and immediate communication with law enforcement during lawful encounters. 3. Avoiding any actions that could be perceived as threatening or evasive. 4. Recognizing that proactive compliance with the law is the safest and most responsible course of action. Question 6. Upon reviewing the Montana Concealed Weapon Permit, CWP requirements, a permit holder is attending a public town hall meeting hosted in a county-owned building. The building has a sign at the main entrance stating "No firearms allowed." Considering Montana law, what is the most legally sound course of action for the permit holder? Option A. Carry the concealed weapon but keep it concealed and do not display it, believing this satisfies the law. Option B. Carry the concealed weapon into the county building, assuming the permit overrides general signage. Option C. Carry the concealed weapon and inform the building security that they are a permit holder, assuming this grants them access. Option D. Refrain from carrying the concealed weapon into the county building due to the posted signage and the nature of the location. The correct answer is D. Refrain from carrying the concealed weapon into the county building due to the posted signage and the nature of the location. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an individual to navigate the intersection of personal rights, public safety, and legal obligations under Montana law concerning concealed carry. The core challenge lies in understanding the nuances of when and where a concealed weapon permit holder can legally carry a firearm, particularly in locations that may have specific restrictions or where the presence of a firearm could cause alarm, even if legally permissible. Misinterpreting these regulations can lead to serious legal consequences and compromise public trust. Correct approach analysis. The best professional approach involves a thorough understanding and strict adherence to Montana's concealed weapon laws, specifically regarding prohibited places. This means recognizing that, while Montana law generally permits concealed carry with a valid permit, there are explicit statutory exceptions. A permit holder must be aware of and respect these exceptions, such as carrying a concealed weapon in a state or municipal building that has been specifically posted with signs prohibiting firearms, or in a federal building. This approach prioritizes legal compliance and public safety by respecting the boundaries set by the legislature. Incorrect approach is analysis. One incorrect approach is to assume that a concealed weapon permit grants unrestricted carry privileges anywhere within Montana, disregarding any posted signage or specific statutory prohibitions. This fails to acknowledge that the permit is subject to limitations outlined in Montana Code Annotated, MCA, Title 45, Chapter 8, Part 3. Another incorrect approach is to rely on personal interpretation of what constitutes a safe or appropriate location, rather than consulting the explicit legal definitions and restrictions provided by Montana law. This subjective judgment can lead to violations. Finally, an incorrect approach would be to carry a concealed weapon into a location where it is explicitly prohibited by statute, such as a courthouse or a polling place on election day, regardless of whether signage is present, as the statute itself creates the prohibition. Professional reasoning. Professionals in this situation should employ a decision-making framework that begins with a comprehensive review of the relevant Montana statutes governing concealed carry. This includes understanding the definition of prohibited places and the conditions under which carrying a concealed weapon is permissible. When in doubt about the legality of carrying in a specific location, the professional standard is to err on the side of caution and seek clarification from legal counsel or relevant law enforcement agencies, or to refrain from carrying in that location. This proactive approach ensures compliance and minimizes risk. Question 7. When evaluating the permissible locations for carrying a concealed weapon with a valid Montana concealed weapon permit, which of the following actions best demonstrates adherence to Montana's regulatory framework? Option A. Assuming that a concealed weapon permit allows carrying a concealed weapon in all public and private establishments within Montana, regardless of any posted signs or specific statutory exclusions. Option B. Consulting Montana Code Annotated Title 45, Chapter 8, Part 3, to understand the specific statutory definitions of prohibited locations and recognizing that carry is generally permitted elsewhere, unless explicitly restricted by statute or legally posted private property signage. Option C. Believing that any sign posted on private property prohibiting firearms is legally binding and automatically restricts concealed carry, even if the signage does not meet the specific requirements outlined in Montana law. Option D. Relying on advice from fellow permit holders or online discussions to determine where concealed carry is permitted, without verifying the information against official state statutes. The correct answer is B. Consulting Montana Code Annotated Title 45, Chapter 8, Part 3, to understand the specific statutory definitions of prohibited locations and recognizing that carry is generally permitted elsewhere, unless explicitly restricted by statute or legally posted private property signage. Explanation. Scenario analysis. This scenario presents a professional challenge involving the interpretation and application of Montana's concealed weapon permit laws, specifically concerning the permissible locations for carrying a concealed weapon. A permit holder must exercise careful judgment to avoid violating state statutes, which could lead to legal penalties and the revocation of their permit. Understanding the nuances of where a permit is valid is crucial for responsible firearm ownership and adherence to the law. Correct approach analysis. The best professional practice involves a thorough understanding of Montana Code Annotated, MCA, Title 45, Chapter 8, Part 3, which governs concealed weapons. Specifically, MCA 45-8-361 outlines the locations where a concealed weapon may be carried by a permit holder. This approach requires the permit holder to actively consult and understand the statutory definitions of prohibited locations, such as schools, courthouses, and federal buildings, and to recognize that the permit generally allows concealed carry in most other public and private spaces, unless explicitly prohibited by statute or private property signage, that complies with MCA 45-8-361-2. This proactive and informed approach ensures compliance with the law. Incorrect approaches analysis. One incorrect approach is to assume that a concealed weapon permit grants unrestricted carry privileges in all locations. This fails to acknowledge the specific statutory restrictions outlined in MCA 45-8-361. Which clearly delineate prohibited areas. Relying on personal assumptions rather than legal text is a direct violation of regulatory compliance. Another incorrect approach is to rely solely on informal advice from friends or online forums regarding carry locations. While these sources may sometimes offer accurate information, they are not authoritative and can be outdated or misinterpreted. Legal statutes are the definitive source of information, and deviating from them based on informal advice is a significant regulatory failure. A third incorrect approach is to believe that private property owners can arbitrarily prohibit concealed carry without adhering to specific signage requirements as defined by Montana law. MCA 45-8-361. 2. Outlines the specific requirements for private property owners to prohibit concealed carry, and a permit holder must be aware of these requirements rather than assuming any posted sign is legally sufficient. Professional reasoning. Professionals should adopt a decision-making framework that prioritizes legal accuracy and proactive compliance. This involves 1. Identifying the relevant jurisdiction and its specific laws, Montana Code Annotated. 2. Consulting the primary legal sources for definitive guidance on permit holder rights and restrictions. 3. Understanding the definitions and limitations provided within the statutes. 4. Seeking clarification from official sources, e.g., Montana Department of Justice, legal counsel, if any ambiguity exists. 5. Acting with a presumption of adherence to the law rather than assuming broad privileges. Question 8. The analysis reveals that an applicant for a Montana Concealed Weapon Permit, CWP, has a prior misdemeanor conviction for domestic violence. Considering the specific regulatory framework governing CWP eligibility in Montana, which of the following actions best ensures compliance with Montana law? Option A. Directly cross-referencing the applicant's misdemeanor domestic violence conviction with the disqualifying offenses explicitly listed in Montana Code Annotated 45-8-321. Option B. Assuming that any misdemeanor conviction automatically disqualifies an applicant from obtaining a Montana CWP without further investigation. Option C. Attempting to find exceptions or mitigating circumstances in the applicant's history that would allow for a permit despite the domestic violence conviction, without explicit statutory allowance. Option D. Relying on general national standards for firearm possession eligibility rather than Montana's specific statutory requirements. The correct answer is A. Directly cross-referencing the applicant's misdemeanor domestic violence conviction with the disqualifying offenses explicitly listed in Montana Code Annotated 45-8-321. Explanation. The analysis reveals a scenario where an individual seeking a Montana Concealed Weapon Permit, CWP, has a past misdemeanor conviction for domestic violence. This situation is professionally challenging because it requires a precise understanding of Montana's specific eligibility criteria for CWP holders, particularly concerning disqualifying offenses. Misinterpreting or misapplying these statutes can lead to the denial of a permit, or worse, the issuance of a permit to an individual who is legally prohibited from possessing a concealed weapon, creating a significant public safety risk and potential legal liability for the issuing authority. Careful judgment is required to navigate the nuances of Montana Code Annotated, MCA, Title 45, Chapter 8, Part 3, which governs concealed weapon permits. The correct approach involves a thorough review of the applicant's criminal history against the specific disqualifying offenses listed in MCA 45-8-321. This statute explicitly prohibits the issuance of a concealed weapon permit to individuals convicted of certain crimes, including domestic violence offenses. Therefore, a direct comparison of the applicant's misdemeanor domestic violence conviction against the statutory prohibitions is the most direct and legally sound method. This approach ensures compliance with Montana law by adhering to the explicit legislative intent to prevent individuals with such convictions from carrying concealed weapons. An incorrect approach would be to assume that all misdemeanor convictions are automatically disqualifying without consulting the specific language of MCA 45-8-321. This could lead to an overly broad or overly lenient interpretation of the law. Another incorrect approach would be to rely on general assumptions about firearm eligibility rather than the precise Montana statutes. This overlooks the fact that state laws vary significantly, and a CWP is governed by Montana's specific legislative framework. Finally, attempting to bypass or interpret around the clear statutory language based on the perceived character of the applicant or the age of the offense would be a grave ethical and legal failure, as it undermines the rule of law and the public safety mandate of the CWP program. Professionals in this situation should employ a decision-making framework that prioritizes strict adherence to statutory language. This involves 1. Identifying the relevant statute, MCA 45-8-321. 2. Obtaining a complete and accurate criminal history of the applicant. 3. Directly comparing the applicant's conviction, S, to the enumerated disqualifying offenses in the statute. 4. Documenting the findings and the basis for the decision. 5. Consulting legal counsel if any ambiguity exists in the statute or its application to the specific facts. Question: the analysis reveals that an applicant for a Montana Concealed Weapon Permit, CWP, has a prior misdemeanor conviction for domestic violence. Considering the specific regulatory framework governing CWP eligibility in Montana, which of the following actions best ensures compliance with Montana law? Options: A. Directly cross-referencing the applicant's misdemeanor domestic violence conviction with the disqualifying offenses explicitly listed in Montana Code, annotated 45-8-321. B. Assuming that any misdemeanor conviction automatically disqualifies an applicant from obtaining a Montana CWP without further investigation. C. Relying on general national standards for firearm possession eligibility rather than Montana's specific statutory requirements. D. Attempting to find exceptions or mitigating circumstances in the applicant's history that would allow for a permit despite the domestic violence conviction, without explicit statutory allowance. Question 9. Comparative studies suggest that responsible firearm ownership is a critical aspect of exercising concealed carry rights. In Montana, a licensed concealed weapon permit holder is involved in a minor verbal disagreement with another individual in a public park. The permit holder feels agitated but is not physically threatened. Which of the following actions best reflects responsible and legally compliant behavior in this situation? Option A. Draw the concealed weapon to assert authority and de-escalate the situation through a show of force. Option B. Discreetly reveal the concealed weapon to a companion to demonstrate preparedness for potential escalation. Option C. Inform the other individual that you are legally carrying a concealed weapon to intimidate them into ending the disagreement. Option D. Maintain composure, keep the concealed weapon concealed, and disengage from the verbal disagreement by walking away. The correct answer is D. Maintain composure, keep the concealed weapon concealed, and disengage from the verbal disagreement by walking away. Explanation: scenario analysis. This scenario is professionally challenging because it requires an individual to navigate the nuances of Montana's concealed weapon laws while also considering the ethical implications of their actions. The core challenge lies in distinguishing between lawful possession and the potential for misuse or creating a public disturbance, even when acting within legal bounds. Careful judgment is required to ensure that exercising a right does not infringe upon the safety or peace of others. Correct approach analysis. The best professional practice involves understanding that while Montana law permits concealed carry for permit holders. Responsible gun ownership also necessitates discretion and awareness of one's surroundings. This approach prioritizes de-escalation and avoiding unnecessary attention or alarm. It recognizes that even if legally permitted, openly displaying or brandishing a concealed weapon, even without intent to harm, can be perceived as threatening and may lead to unintended consequences, including potential legal scrutiny or public panic. This aligns with the spirit of responsible firearm ownership, which emphasizes safety and minimizing risk. Incorrect approach is analysis. One incorrect approach involves assuming that simply possessing a concealed weapon permit in Montana grants an unfettered right to display or draw the weapon in any situation, regardless of context or potential for causing alarm. This fails to consider the broader implications of public safety and the potential for misinterpretation of actions, which could lead to calls for law enforcement intervention or accusations of brandishing. Another incorrect approach is to believe that the permit absolves one of any responsibility to consider the emotional or psychological impact of their actions on others in public spaces. This overlooks the ethical dimension of responsible gun ownership, which extends beyond mere legal compliance to include a duty of care towards the community. Finally, an approach that suggests drawing a concealed weapon in response to a minor, non-threatening inconvenience, such as a verbal disagreement, is fundamentally flawed. This demonstrates a lack of judgment and an escalation of a situation that does not warrant such a response, potentially violating the principles of proportional force and responsible self-defense. Professional reasoning. Professionals should approach situations involving concealed carry by first understanding the specific legal allowances and restrictions within Montana. Beyond legalities, they must engage in a continuous assessment of the environment and the potential impact of their actions on others. This includes practicing situational awareness, prioritizing de-escalation, and understanding that the right to carry does not equate to a right to intimidate or provoke. Decision-making should be guided by a principle of minimizing risk and avoiding actions that could be perceived as threatening, even if technically legal. Question 10. The investigation demonstrates that a Montana concealed weapon permit holder's permit is set to expire on October 15, 2024. The statutory renewal fee for a Montana concealed weapon permit is $75. Montana law stipulates that a renewal application received after the expiration date, but within 30 days of the expiration date, will incur a late fee of $15. If the permit holder submits their renewal application on November 10, 2024, what will be the total cost of their permit renewal? Option A, $75. Option B, $105. Option C, $60. Option D, $90. The correct answer is D, $90. Explanation. The investigation demonstrates a scenario where a concealed weapon permit holder in Montana is seeking to understand the financial implications of renewing their permit, specifically concerning the renewal fee and the potential for a late fee. This scenario is professionally challenging because it requires the applicant to accurately calculate potential costs based on specific dates and fee structures, ensuring compliance with Montana's concealed weapon permit regulations to avoid penalties. Misinterpreting the renewal window or fee structure could lead to financial penalties or even the lapse of their permit, necessitating a new application process. The correct approach involves precisely calculating the renewal fee based on the permit's expiration date and the statutory renewal fee, and then determining if the renewal is being submitted within the grace period. Montana law specifies the renewal fee and the period within which renewal can occur without penalty. For example, if the permit expires on June 1st, and the renewal fee is $50, and the late fee is $25, and the applicant submits the renewal on June 15th, the calculation would be renewal fee plus late fee equals total cost. In this example, $50 plus $25 equals $75. This approach is correct because it directly applies the established fee structure and timelines outlined in Montana's concealed weapon permit statutes, ensuring accurate financial planning and timely compliance. An incorrect approach would be to estimate the renewal fee without consulting the official fee schedule, or to assume a grace period that does not exist in Montana law. For instance, simply paying the base renewal fee without considering the possibility of a late fee, even if the renewal is submitted after the expiration date but within a presumed grace period, is a regulatory failure. Another incorrect approach would be to calculate the renewal fee based on a hypothetical fee structure, not aligned with Montana's actual statutes, leading to an underpayment or overpayment and potential complications with the permit renewal process. Professionals should approach such situations by first identifying the specific governing regulations for concealed weapon permits in Montana. They should then locate the official fee schedule and renewal period guidelines. Using these official sources, they can perform precise calculations based on the individual's permit expiration date. If there is any ambiguity, seeking clarification from the issuing authority is a crucial step in ensuring accurate compliance and avoiding penalties. Question 11. Analysis of Montana's concealed weapon laws, specifically regarding permissible locations for permit holders. What is the correct course of action for an individual possessing a valid Montana concealed weapon permit (CWP) when entering a privately owned retail store that has not posted any signage prohibiting firearms? Option A. Carry the concealed weapon, believing the permit grants unrestricted access to all locations. Option B. Carry the concealed weapon, as private businesses are not explicitly listed as prohibited locations in Montana law unless signage is present. Option C. Do not carry the concealed weapon, relying on informal advice received from acquaintances about restricted areas. Option D. Do not carry the concealed weapon, as a general assumption of caution dictates avoiding all private establishments. The correct answer is B. Carry the concealed weapon, as private businesses are not explicitly listed as prohibited locations in Montana law unless signage is present. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an individual to navigate the nuances of Montana's concealed weapon laws, specifically concerning the permissible locations for carrying a concealed weapon. Misinterpreting these regulations can lead to serious legal consequences, including criminal charges and the revocation of a concealed weapon permit. The professional challenge lies in applying the law accurately to a specific, everyday situation, demonstrating a thorough understanding beyond rote memorization. Correct approach analysis. The best professional approach involves a precise understanding of Montana Code Annotated, MCA, Title 45, Chapter 8, Part 3, which governs concealed weapons. Specifically, MCA 45-8-361 outlines prohibited places. Permit holder must know that carrying a concealed weapon is prohibited in places where federal law prohibits firearms, such as federal buildings, and in specific Montana-governed locations like courthouses, correctional facilities, and polling places on election day. The correct approach is to recognize that a private business, unless it has explicitly posted signage prohibiting firearms in accordance with MCA 45-8-361, 2, is generally permissible for a concealed weapon permit holder to carry in. This approach demonstrates adherence to the specific statutory exceptions and prohibitions. Incorrect approach is analysis. One incorrect approach is to assume that any private business is off-limits due to a general sense of caution or a misunderstanding that all private property is restricted. This fails to recognize that Montana law specifically enumerates prohibited locations, and private businesses are not automatically included unless posted. This approach overextends the restrictions beyond the statutory framework. Another incorrect approach is to believe that a concealed weapon permit automatically grants permission to carry in all locations, including those explicitly prohibited by statute. This demonstrates a lack of understanding of the limitations and responsibilities that come with a permit, ignoring the specific prohibitions outlined in MCA 45-8-361. A third incorrect approach is to rely on hearsay or informal advice from others regarding weapon restrictions, rather than consulting the actual Montana Code Annotated. This can lead to the adoption of inaccurate interpretations of the law, which are not legally binding and can result in violations. Professional reasoning. Professionals should adopt a decision-making process that prioritizes direct consultation of the relevant statutes and regulations. When faced with a question about carrying a concealed weapon, the first step is to identify the specific jurisdiction, Montana, and then locate the governing statutes, MCA Title 45, Chapter 8, Part 3. The next step is to carefully review the definitions and prohibitions within those statutes, paying close attention to the enumerated list of prohibited locations. If a situation involves a private business, the professional must then consider MCA 45-8-361, 2, regarding signage. If there is any ambiguity, seeking clarification from official sources or legal counsel is advisable, rather than making assumptions or relying on unverified information. Question 12. Consider a scenario where an applicant for a concealed weapon permit in Montana has a documented history of a domestic disturbance call to their residence, which, while not resulting in an arrest or conviction, involved allegations of aggressive behavior. The applicant states it was a misunderstanding and has provided character references. How should the Montana Sheriff's Department, as the issuing authority, proceed in evaluating this applicant's eligibility for a concealed weapon permit? Option A. Grant the permit based solely on the applicant's explanation of the incident as a misunderstanding and the provided character references, without independently assessing the nature of the disturbance. Option B. Issue the permit without further investigation, assuming the applicant is eligible because no criminal charges were filed. Option C. Conduct a thorough review of the domestic disturbance incident, considering the allegations of aggressive behavior in conjunction with Montana Code, annotated 45-8-302 regarding grounds for denial, and evaluate the applicant's overall suitability for a permit based on the totality of the circumstances and statutory requirements. Option D. Automatically deny the permit application due to the involvement in a domestic disturbance call, irrespective of the lack of arrest or conviction. The correct answer is C. Conduct a thorough review of the domestic disturbance incident, considering the allegations of aggressive behavior in conjunction with Montana Code, annotated 45-8-302 regarding grounds for denial, and evaluate the applicant's overall suitability for a permit based on the totality of the circumstances and statutory requirements. Explanation. Scenario analysis. This scenario is professionally challenging because it involves a direct conflict between a citizen's perceived right to carry a concealed weapon and the specific legal requirements for obtaining and maintaining a permit in Montana. The individual's past behavior, even if not resulting in a conviction, raises concerns about their suitability to carry a concealed weapon, requiring careful consideration of Montana's concealed weapon permit laws and the discretion afforded to the issuing authority. Correct approach analysis. The best professional approach involves a thorough review of the applicant's history against the specific criteria outlined in Montana Code annotated MCA Title 45, Chapter 8, Part 3, which governs concealed weapon permits. This includes examining whether the past incident, even without a conviction, might fall under grounds for denial as defined by MCA 45-8-302, such as demonstrating a propensity for violence or posing a risk to public safety. The issuing authority must exercise its discretion based on the totality of the circumstances and the statutory requirements for permit issuance, prioritizing public safety and adherence to the law. This approach ensures compliance with Montana's legal framework for concealed weapon permits. Incorrect approaches analysis. One incorrect approach would be to automatically deny the permit solely because the applicant was involved in an incident, regardless of whether it resulted in a conviction or if the incident meets the statutory criteria for denial. This fails to adhere to the legal standard, which requires a determination based on specific grounds for denial outlined in the MCA, not on mere involvement in an event. Another incorrect approach would be to grant the permit without any further investigation or consideration of the incident, assuming that the absence of a conviction means the applicant is automatically eligible. This disregards the issuing authority's duty to assess the applicant's suitability and potential risk to public safety as mandated by Montana law, which allows for denial based on factors beyond just criminal convictions. A further incorrect approach would be to base the decision solely on the applicant's subjective assertion that the incident was a misunderstanding, without independently verifying the facts or considering the potential implications of the incident as it relates to the applicant's fitness to carry a concealed weapon under Montana law. This bypasses the necessary due diligence required to uphold public safety. Professional reasoning. Professionals in this situation must employ a structured decision-making process. First, they must identify the relevant legal framework, Montana Code annotated Title 45, Chapter 8, Part 3. Second, they must gather all available information regarding the applicant's history, including the details of the past incident. Third, they must objectively assess this information against the specific statutory grounds for permit issuance and denial. Fourth, they must exercise their discretion judiciously, prioritizing public safety and adherence to the law. Finally, they must document their decision-making process thoroughly, justifying their conclusion based on the legal requirements and the evidence presented. Question 13. During the evaluation of a traffic stop in Montana, a permit holder is asked by the issuing officer to produce their driver's license and vehicle registration. The permit holder has a valid Montana concealed weapon permit and a concealed firearm on their person. Which of the following actions best demonstrates compliance with Montana law and professional responsibility? Option A. Wait for the officer to discover the concealed weapon during a pat-down before mentioning the permit. Option B. Immediately inform the officer about the concealed weapon and present the Montana concealed weapon permit. Option C. Remain silent about the concealed weapon and permit unless directly questioned about it. Option D. Only present the Montana concealed weapon permit when specifically asked about the firearm. The correct answer is B. Immediately inform the officer about the concealed weapon and present the Montana concealed weapon permit. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an individual to navigate the nuances of Montana's concealed weapon laws while also considering the ethical implications of their actions in a public setting. The core challenge lies in balancing the legal right to carry a concealed weapon with the responsibility to do so in a manner that does not cause undue alarm or violate public safety expectations, especially when interacting with law enforcement. Careful judgment is required to ensure compliance with Montana Code Annotated, MCA Title 45, Chapter 8, Part 3, which governs concealed weapon permits, and to act in a way that is both legally sound and socially responsible. Correct approach analysis. The best professional practice involves immediately and clearly informing the law enforcement officer of the presence of a concealed weapon and the existence of a valid Montana concealed weapon permit. This approach is correct because MCA 45-8-361-3 mandates that a person possessing a concealed weapon permit who is stopped by a peace officer shall, upon request, display the permit and identify the location of the concealed weapon. Proactive and transparent communication with law enforcement is crucial for de-escalation, officer safety, and demonstrating responsible permit holder conduct. It aligns with the spirit of the law, which aims to allow law-abiding citizens to carry concealed weapons while ensuring public safety through a permitting process and clear guidelines for interaction with law enforcement. Incorrect approach is analysis. One incorrect approach is to remain silent about the concealed weapon and permit, hoping the officer does not discover it. This is a significant regulatory failure, as it directly violates MCA 45-8-361-3 by not displaying the permit or identifying the weapon upon request or implied request during a stop. Ethically, it erodes trust between permit holders and law enforcement and creates a potentially dangerous situation for the officer. Another incorrect approach is to only reveal the concealed weapon after the officer has already discovered it through a pat-down or visual observation. While this might eventually lead to the permit being shown, it bypasses the proactive communication required by the statute and can be perceived as evasive or even threatening by the officer, increasing the risk of a negative encounter. It fails to meet the expectation of immediate and voluntary disclosure. A third incorrect approach is to present the concealed weapon permit but refuse to disclose the location of the weapon, arguing that the permit itself is sufficient. This is a regulatory failure because MCA 45-8-361-3 specifically requires identifying the location of the concealed weapon, not just possessing the permit. The law is designed to ensure officer safety by knowing where the weapon is, and withholding this information undermines that purpose. Professional reasoning. Professionals should adopt a decision-making framework that prioritizes transparency, legal compliance, and de-escalation when interacting with law enforcement while carrying a concealed weapon. This involves understanding the specific requirements of Montana law, particularly MCA 45-8-361-3, and acting proactively to inform the officer. The guiding principle should be to facilitate a safe and lawful interaction by providing all necessary information promptly and respectfully, thereby demonstrating responsible gun ownership and adherence to legal obligations. Question 14. Research into Montana's concealed weapon permit regulations reveals that certain locations are designated as prohibited for carrying firearms, even with a valid permit. Considering the legal framework established by Montana Code Annotated Title 45, Chapter 8, Part 3. What is the most responsible course of action for a concealed weapon permit holder when entering a building that houses a courthouse and also contains private businesses, and the specific signage regarding firearm restrictions within the private business areas is unclear? Option A. Proceed to carry the concealed weapon into the private business areas, assuming that the prohibition primarily applies to the courthouse section and that private businesses have no such restrictions unless explicitly posted. Option B. Immediately seek out building security or law enforcement within the courthouse section to ask for clarification on the private business area's policies while carrying the concealed weapon. Option C. Carry the concealed weapon openly into the private business areas to avoid any ambiguity about intent, even though the permit is for concealed carry. Option D. Exercise caution by refraining from carrying the concealed weapon into the building until the specific restrictions for the private business areas can be definitively ascertained, or by leaving the weapon secured elsewhere if the entire building is considered a prohibited zone. The correct answer is D. Exercise caution by refraining from carrying the concealed weapon into the building until the specific restrictions for the private business areas can be definitively ascertained, or by leaving the weapon secured elsewhere if the entire building is considered a prohibited zone. Explanation. Scenario analysis. This scenario presents a professional challenge involving the interpretation and application of Montana's concealed weapon permit laws in a dynamic public setting. The core difficulty lies in balancing an individual's right to carry a concealed weapon with the responsibility to adhere to specific location-based restrictions, especially when those restrictions are not immediately obvious or universally understood. Careful judgment is required to avoid both unnecessary confrontation and potential legal violations. Correct approach analysis. The best professional practice involves a proactive and informed approach to understanding and complying with Montana's concealed weapon laws, particularly regarding prohibited locations. This includes familiarizing oneself with Montana Code Annotated, MCA, Title 45, Chapter 8, Part 3, which outlines the regulations for carrying concealed weapons and specifies prohibited places such as courthouses, correctional facilities, and schools. When encountering a location where carrying a concealed weapon might be restricted, the most prudent action is to err on the side of caution by not carrying the weapon into that specific area, or by seeking explicit clarification from the establishment's management or relevant authorities if permitted by law. This approach prioritizes legal compliance and public safety, aligning with the intent of the concealed weapon permit system. Incorrect approach is analysis. One incorrect approach is to assume that carrying a concealed weapon is permissible in all public places, unless explicitly posted with a firearm prohibition sign. Montana law does not solely rely on signage for restrictions. Certain locations are inherently prohibited regardless of posted notices. Another incorrect approach is to carry a concealed weapon into a location that is known or reasonably suspected to be a prohibited area, such as a government building or a school, without verifying the legality. This demonstrates a lack of due diligence and a disregard for the specific restrictions outlined in Montana statutes. Finally, engaging in a debate or confrontation with authorities or establishment staff regarding the legality of carrying a concealed weapon in a potentially prohibited area, without first seeking to understand and comply with the law, is unprofessional and can escalate the situation unnecessarily. Professional reasoning. Professionals should adopt a framework of continuous learning and situational awareness. This involves regularly reviewing the relevant Montana statutes governing concealed weapons, understanding the definitions of prohibited locations, and exercising sound judgment in ambiguous situations. When in doubt, the professional decision-making process should prioritize compliance with the law and public safety over personal convenience or assertion of rights. Seeking clarification from official sources or choosing not to carry in potentially restricted areas are the most responsible actions. Question 15. The monitoring system indicates a permit holder has entered a private establishment in Montana. Considering Montana Code Annotated Section 45-8-361, which outlines specific prohibitions for carrying concealed weapons, what is the most appropriate immediate action for the permit holder to ensure compliance with state law? Option A. Assume that a valid Montana concealed weapon permit allows carrying in all private establishments, unless explicitly told otherwise by law enforcement. Option B. Verify if the specific private establishment is listed as a prohibited location under Montana Code Annotated Section 45-8-361, or if there is any posted signage indicating a prohibition on carrying firearms. Option C. Immediately leave the establishment and contact the local sheriff's office to inquire about the legality of carrying in that specific private establishment. Option D. Proceed with carrying the concealed weapon, as Montana law generally permits concealed carry in private establishments unless specifically prohibited by statute. Correct answer is B. Verify if the specific private establishment is listed as a prohibited location under Montana Code Annotated Section 45-8-361, or if there is any posted signage indicating a prohibition on carrying firearms. Explanation: the monitoring system demonstrates a potential lapse in adherence to Montana's concealed weapon permit regulations. This scenario is professionally challenging because it requires immediate and accurate judgment regarding the legality of carrying a firearm in a specific location, balancing individual rights with public safety and statutory requirements. A failure to correctly interpret and apply Montana law could lead to serious legal consequences for the permit holder and potentially impact the establishment's liability. The correct approach involves understanding the specific prohibitions outlined in Montana law regarding carrying concealed weapons. Montana Code Annotated MCA, Section 45-8-361 outlines places where carrying a concealed weapon is prohibited, even with a valid permit. This includes, but is not limited to, federal buildings, courthouses, and correctional facilities. However, it generally permits carrying in most other public places unless specifically posted otherwise by private entities or by specific statutory exclusion. Therefore, the most prudent and legally compliant action is to verify the specific location status against Montana's statutory prohibitions and any posted signage. An incorrect approach would be to assume that a valid Montana Concealed Weapon Permit, CWP, grants unrestricted carry privileges in all locations. This ignores the explicit exceptions and restrictions detailed in MCA Section 45-8-361. Another incorrect approach is to rely solely on the absence of explicit no-gun signage, as Montana law does not require private establishments to post such signs to prohibit concealed carry. The prohibition can be statutory or, in some cases, communicated verbally or through other means. Finally, assuming that carrying a concealed weapon in a private establishment is permissible without confirming the establishment's specific policies or statutory restrictions is also an unacceptable approach, as it bypasses due diligence required by law. Professionals should employ a decision-making framework that prioritizes understanding and adherence to the specific statutes governing concealed carry in Montana. This involves 1. Knowing the general provisions of the Montana CWP. 2. Being intimately familiar with the specific locations and circumstances where carrying a concealed weapon is statutorily prohibited under MCA Section 45-8-361. 3. Actively seeking information about the specific location status, including checking for posted signage, and if necessary, inquiring with the establishment's management about their policies, especially in borderline situations. 4. When in doubt, err on the side of caution and refrain from carrying the concealed weapon in that location. Question 16. The control framework reveals that a new resident of Montana who has recently relocated from another state is preparing to apply for a Montana Concealed Weapon Permit, CWP. This individual has a valid CWP from their previous state and believes it will be automatically recognized or easily transferable. What is the most appropriate course of action to ensure compliance with Montana's concealed weapon laws? Option A. Research Montana's specific requirements for obtaining a concealed weapon permit, including residency, training, and application procedures, and apply accordingly, understanding that out-of-state permits may not be directly transferable. Option B. Contact the Montana Department of Justice to inquire about the process of transferring an out-of-state CWP, expecting a simple endorsement or amendment to the existing permit. Option C. Assume that the previous state's CWP is valid in Montana due to reciprocity agreements, and proceed with carrying a concealed weapon. Option D. Carry a concealed weapon under the assumption that Montana law allows for concealed carry by residents who possess a valid permit from any other U.S. state. The correct answer is A. Research Montana's specific requirements for obtaining a concealed weapon permit, including residency, training, and application procedures, and apply accordingly, understanding that out-of-state permits may not be directly transferable. Explanation: the control framework reveals a scenario where an individual, having recently moved to Montana, is seeking to carry a concealed weapon. The situation is professionally challenging because it requires strict adherence to Montana's specific concealed weapon permit (CWP) laws, which differ from those in other states or jurisdictions. Misunderstanding or misapplying these laws can lead to serious legal consequences, including criminal charges and the denial of permit privileges. Careful judgment is required to ensure all legal prerequisites are met before carrying a concealed weapon. The best professional practice involves thoroughly understanding and complying with Montana's statutory requirements for obtaining a concealed weapon permit. This includes verifying residency, completing the required training, submitting a complete application with all necessary documentation, and undergoing a background check as mandated by Montana law. This approach ensures legal compliance and responsible firearm ownership within the state's regulatory framework. Failing to meet Montana's residency requirements before applying for a CWP is a direct violation of Montana Code Annotated (MCA) 45-8-321, which specifies residency as a prerequisite for permit issuance. Providing incomplete or inaccurate information on the application, such as omitting required training certificates or misrepresenting personal history, constitutes a violation of the application process outlined in MCA 45-8-321 and can lead to application denial or revocation of a permit if issued. Attempting to carry a concealed weapon without a valid permit or before all permit requirements are met is a violation of MCA 45-8-321 and can result in criminal charges. Professionals should employ a decision-making framework that prioritizes understanding the specific legal requirements of the jurisdiction in question. This involves consulting the relevant statutes, in this case, Montana Code Annotated, and any administrative rules or guidance issued by the Montana Department of Justice. A systematic approach of verifying each requirement against the law, gathering all necessary documentation, and completing all mandated steps before taking any action that requires a permit is crucial for ensuring compliance and avoiding legal pitfalls. Question 17. The performance metrics show a significant increase in concealed weapon permit applications being denied in Montana due to applicants submitting incomplete or inaccurate information. Considering the regulatory framework for concealed weapon permits in Montana, which of the following actions would be the most effective and professionally responsible response to address this trend? Option A. Review and revise the application form and accompanying instructions to enhance clarity and provide more comprehensive guidance to applicants, along with developing easily accessible resources to explain common errors and requirements. Option B. Increase the number of staff dedicated to reviewing applications, with the primary directive to identify and flag any perceived inaccuracies for immediate denial. Option C. Implement a policy to automatically deny any application containing even minor omissions or inaccuracies, regardless of the applicant's eligibility otherwise. Option D. Focus on developing more stringent background check procedures that do not address the initial submission quality of the application itself. The correct answer is A. Review and revise the application form and accompanying instructions to enhance clarity and provide more comprehensive guidance to applicants, along with developing easily accessible resources to explain common errors and requirements. Explanation: the performance metrics show a concerning trend in the number of concealed weapon permit applications being denied due to incomplete or inaccurate information submitted by applicants. This scenario is professionally challenging because it requires balancing the state's mandate to ensure public safety through a thorough vetting process with the need to provide clear, accessible guidance to applicants. A failure to do so can lead to legitimate permit holders being unfairly denied or, conversely, potentially unqualified individuals obtaining permits. Careful judgment is required to identify the root cause of these errors and implement effective solutions. The best approach involves proactively addressing the identified deficiency by reviewing and enhancing the clarity and accessibility of the application materials and guidance provided by the Montana Department of Justice. This includes ensuring that the application form itself is unambiguous, that accompanying instructions are easy to understand, and that readily available resources, such as FAQs or informational pamphlets, clearly outline common pitfalls and requirements. This approach is correct because it directly tackles the observed problem by improving the applicant's ability to comply with Montana's concealed weapon permit requirements, as outlined in Montana Code Annotated, MCA, Title 45, Chapter 8, Part 3. By making the process more transparent and user-friendly, the Department of Justice fulfills its obligation to administer the permit system effectively and fairly, reducing the likelihood of denials based on procedural errors rather than substantive disqualifications. An approach that involves simply increasing the denial rate without addressing the underlying causes of incomplete applications is professionally unacceptable. This would fail to uphold the principle of fairness and could lead to an increase in appeals and administrative burden, without improving the quality of information received. It also neglects the department's responsibility to guide applicants through the process. Another unacceptable approach is to assume that applicants are intentionally providing inaccurate information and to implement stricter, more punitive measures without investigating the reasons for the errors. This overlooks the possibility that the application process itself may be confusing, or that applicants may lack understanding of the requirements. Such an approach would be ethically questionable and could lead to a perception of bias or unreasonableness in the administration of the permit system. Finally, an approach that focuses solely on training application reviewers to be more lenient in accepting incomplete applications would be professionally unsound. While some flexibility might be warranted in certain edge cases, a wholesale relaxation of standards would undermine the integrity of the background check process and compromise public safety, which is the primary objective of the concealed weapon permit system. Professionals should employ a data-driven decision-making framework. This involves 1. Identifying performance metrics that indicate a problem, as done here with application denials due to incomplete information. 2. Analyzing the root causes of the problem, e.g., unclear instructions, complex forms. 3. Developing targeted solutions that address these root causes, e.g., revising application materials, providing better guidance. 4. Implementing the solutions and monitoring their effectiveness through ongoing performance metrics. And 5. Iterating the process as needed to ensure continuous improvement in the administration of the permit system. Question 18. System analysis indicates a Montana concealed weapon permit holder is involved in a verbal dispute in a public park. The individual feels threatened by the other party's aggressive demeanor and proximity, but there is no immediate physical contact or overt display of a weapon by the aggressor. What is the most legally compliant and professionally responsible course of action for the permit holder? Option A. Verbally threaten the aggressor with the firearm, even if it remains concealed, to assert dominance and end the dispute. Option B. Assume the permit allows for the display of the firearm in any situation where they feel threatened and proceed to unholster it. Option C. Keep the firearm concealed, attempt to de-escalate or disengage from the confrontation, and if necessary, contact law enforcement. Option D. Unholster the firearm and display it to the aggressor to demonstrate readiness for self-defense. The correct answer is C. Keep the firearm concealed, attempt to de-escalate or disengage from the confrontation, and if necessary, contact law enforcement. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an individual to navigate the intersection of personal rights, public safety, and specific state statutes regarding concealed carry. The challenge lies in accurately interpreting and applying Montana law to a situation where a permit holder's actions, while seemingly minor, could have significant legal and safety implications. Careful judgment is required to ensure compliance with the Montana Firearms Act and to avoid actions that could jeopardize their permit or public trust. Correct approach analysis. The best professional practice involves understanding that a Montana Concealed Weapon Permit, CWP, authorizes the concealed carry of a handgun, does not grant permission to display or brandish the firearm in a manner that could be perceived as threatening or provocative, especially in a situation that does not involve immediate self-defense. Therefore, the most appropriate action is to remain calm, keep the firearm concealed as permitted, and disengage from the confrontation if possible, or to call law enforcement if the situation escalates and poses a threat. This approach adheres to the spirit and letter of Montana law, which permits concealed carry for self-defense, but does not condone its use for intimidation or as a tool in non-threatening disputes. Incorrect approach is analysis. One incorrect approach is to unholster the firearm and display it to de-escalate the situation. This action is a violation of Montana law, as it constitutes brandishing a weapon, which is illegal even for a permit holder, unless there is an immediate threat of serious bodily harm. Such an action can lead to criminal charges and the revocation of the CWP. Another incorrect approach is to verbally threaten the individual with the firearm, even if it remains concealed. This is also a form of intimidation and can be construed as a threat, potentially leading to criminal charges and permit revocation. Montana law focuses on the right to carry for self-defense, not for aggressive posturing or verbal threats. A further incorrect approach is to assume that having a CWP automatically permits the use of the firearm in any confrontational situation. This demonstrates a fundamental misunderstanding of the law. The permit grants the right to carry concealed, but the use of the firearm is governed by laws pertaining to self-defense, which require an imminent threat of death or serious bodily injury. Professional reasoning. Professionals in this situation should employ a decision-making framework that prioritizes de-escalation and strict adherence to legal statutes. This involves 1. Assessing the immediate threat level. Is there an imminent danger of death or serious bodily injury? 2. Understanding legal boundaries. What actions are permitted and prohibited under Montana's concealed carry laws and self-defense statutes? 3. Prioritizing safety. Taking steps to ensure personal safety and the safety of others, which often means avoiding escalation. 4. Knowing when to disengage or seek assistance. Recognizing when a situation is beyond personal resolution and contacting law enforcement is the appropriate course of action. Question 19. Which approach would be most prudent for a Montana concealed weapon permit holder who encounters a sign at the entrance of a private business stating, "No firearms allowed," when the permit holder is unsure if this specific type of private business is legally mandated to prohibit firearms under Montana law? Option A. Enter the business and inquire with the owner or manager about the specific legal basis for their "no firearms allowed" policy, asserting the right to carry based on the Montana concealed weapon permit. Option B. Carefully review personal knowledge of Montana code annotated regarding prohibited locations for concealed carry, and if the business type is not explicitly listed as prohibited by state law, proceed to enter the business while remaining aware of any further instructions or legal requirements. Option C. Immediately leave the business premises without entering, assuming any posted sign constitutes a legally binding prohibition for all private establishments. Option D. Assume the sign is a general advisory and proceed to enter the business, carrying the concealed weapon as permitted by the state, as long as the business is not a federal building or courthouse. Correct answer is B. Carefully review personal knowledge of Montana code annotated regarding prohibited locations for concealed carry, and if the business type is not explicitly listed as prohibited by state law, proceed to enter the business while remaining aware of any further instructions or legal requirements. Explanation. This scenario is professionally challenging because it requires an individual to navigate the intersection of personal rights and public safety regulations, specifically concerning the carrying of a concealed weapon in Montana. The core challenge lies in understanding the nuances of Montana law regarding when and where a concealed weapon permit holder may lawfully carry a firearm, and how to respond when encountering a situation that might seem to restrict this right, even if it doesn't legally. Careful judgment is required to avoid violating state statutes while also respecting the rights of others and maintaining personal safety. The best approach involves a thorough understanding of Montana's concealed weapon laws, including specific prohibitions and exceptions. This means recognizing that while a permit generally allows concealed carry, there are designated places where firearms are prohibited, such as federal buildings, courthouses, and schools, with specific exceptions for those authorized. It also means understanding that private property owners can post signs prohibiting firearms, and that a permit holder must comply with these posted restrictions. Therefore, when encountering a situation that might appear to be a restriction, the permit holder's primary responsibility is to ascertain the actual legal status of carrying a firearm in that specific location according to Montana law. This involves consulting the permit holder's knowledge of the law and, if unsure, erring on the side of caution by not carrying the weapon in that location until legal clarity is obtained. This approach is correct because it prioritizes strict adherence to Montana Code Annotated, MCA, Title 45, Chapter 8, Part 3, which governs concealed weapons. It upholds the legal framework designed to balance the right to self-defense with public safety concerns. An incorrect approach would be to assume that any sign or verbal request from a private individual, even if they are the property owner, automatically overrides the concealed weapon permit without verifying the legality of the restriction under Montana law. For instance, simply leaving a business because a sign is posted without confirming if that sign has legal standing under MCA is a failure to exercise due diligence. Another incorrect approach would be to assert one's right to carry based solely on possessing a permit, without considering the specific location's legal status or any posted prohibitions that are legally enforceable. This could lead to a violation of MCA 45-8-361, which outlines prohibited places. Furthermore, engaging in a confrontation or refusing to comply with a legally enforceable restriction based on a misunderstanding of the law is a significant ethical and legal failure. Professionals should employ a decision-making framework that begins with a comprehensive understanding of the relevant statutes and regulations. When faced with a potential restriction, the process should involve 1. Identifying the specific location and its nature, e.g., federal building, private business, school. 2. Recalling or researching the specific prohibitions and exceptions outlined in MCA Title 45, Chapter 8, Part 3, and any related administrative rules. 3. If the legality of the restriction is unclear, seeking clarification from reliable sources, e.g., Montana Department of Justice, legal counsel, or choosing to comply with the perceived restriction until clarity is achieved, rather than risking a violation. This systematic approach ensures compliance and promotes responsible firearm ownership. Question 20. Investigation of the financial requirements for obtaining a Montana concealed weapon permit and purchasing a firearm reveals several potential costs. An applicant is applying for a CWP, which has a state-mandated application fee of $70. The background check fee is $15. The applicant is purchasing a handgun with a listed price of $500. What is the total mandatory cost for the applicant to proceed with the permit application and firearm purchase, considering Montana's 5% state sales tax on retail goods? Option A, $607.50. Option B, $592.50. Option C, $585.00. Option D, $622.50. The correct answer is A, $607.50. Explanation: scenario analysis. This scenario presents a professional challenge by requiring the applicant to accurately calculate the total cost of firearm ownership, including mandatory fees and taxes, within a specific time frame. Miscalculation can lead to an incomplete application, delays, or even rejection, impacting the applicant's ability to legally obtain a concealed weapon permit in Montana. The challenge lies in correctly identifying all applicable costs and applying the correct tax rates as stipulated by Montana law. Correct approach analysis. The best approach involves meticulously itemizing all known costs associated with obtaining a Montana concealed weapon permit and the purchase of a firearm. This includes the permit application fee, the background check fee, and the Montana state sales tax on the firearm purchase. The Montana Department of Justice sets the permit fee, and the FBI's National Instant Criminal Background Check System, NICS, has a standard fee. Montana imposes a state sales tax of 5% on retail sales, which applies to the firearm. Therefore, the correct calculation is to sum the permit fee, the NICS fee, and the sales tax calculated on the firearm's price. This approach ensures all legally mandated financial obligations are met, aligning with Montana Code Annotated, MCA Title 45, Chapter 8, Part 3, which governs concealed weapons and related fees. Incorrect approaches analysis. One incorrect approach would be to only consider the permit application fee and the firearm's purchase price, neglecting the background check fee and the state sales tax. This fails to comply with MCA 45-8-321. Which outlines the fees associated with the permit, and Montana's general sales tax laws that apply to retail purchases. Another incorrect approach would be to estimate the sales tax without using the precise 5% rate, or to apply it to the total of the permit and background check fees in addition to the firearm. This demonstrates a lack of adherence to specific tax regulations and a misunderstanding of what constitutes a taxable sale under Montana law. A further incorrect approach would be to include optional costs, such as firearm training courses or holster purchases, in the mandatory fee calculation. While these are advisable for responsible gun ownership, They are not statutory requirements for the permit application or firearm purchase itself, and thus do not factor into the legally mandated financial obligations for the permit. Professional reasoning. Professionals should adopt a systematic and detail-oriented approach to financial calculations related to legal requirements. This involves consulting official fee schedules, understanding applicable tax laws, and clearly distinguishing between mandatory and optional expenses. A step-by-step breakdown, verifying each component against relevant statutes and regulations, ensures accuracy and compliance. In situations involving fees and taxes, always refer to the most current official documentation from the governing bodies in Montana.